Welcome to WAPS TV, TV to die for from Will and Probate Services. I'm Nick Ash, and today I'm going to look a little more in depth at the property and financial affairs lasting power of attorney. When you make a property and financial affairs lasting powers of attorney, there are a number of choices on the form that you fill in. The first choice is whether your attorneys should act jointly and severally, or jointly for some matters and jointly and severally for others. We always advise jointly and severally because it gives the most freedom and flexibility. If you appoint your attorneys jointly, it means that access to internet banking might be limited because they're not allowed to access it on their own. It also means access to cash machines might be limited. It means they have to sign all transactions off together, which can cause problems purely from an administrative point of view. Jointly and severally means one person can do the job at any given time. If you're worried, you might want to put a financial limit and say that your attorneys have to act jointly for transactions over £1,000, for instance, but below £1,000 they can act jointly and severally. One of the other questions on the form is whether the power of attorney should come into force on lack of capacity only. Again, this is a grey area. We always advise that the power of attorney should come into force immediately, because whilst you have capacity, your attorneys can then act at your instruction rather than on your behalf. And it's only when you lack capacity that they can act on your behalf. If you restrict the power of attorney so it only works after lack of capacity, then what you're effectively doing is meaning that a capacity test has to be done each time a decision is made. This makes the whole process unwieldy. So we always recommend that the power of attorney should come into force immediately upon registration. There are lots of other questions and lots of restrictions and instructions that you can put in, but beware. Putting too many restrictions into the document makes it unusable. Putting too many considerations into the document makes the attorney's job really very difficult. The answer is, with a power of attorney, keep it simple. Appoint your attorneys jointly and severally if you can, and make the power of attorney work from the point at which it's registered. Thanks for watching. I hope you found it useful. If you want to find out more or contact us, you can get in touch via our website. Of course, you can follow us across all the normal social media platforms as well, across Facebook, Twitter and LinkedIn. Thanks again. Bye now.